A will is one of the most basic estate planning tools. While relying solely on a will is rarely a suitable option for most people, just about every estate plan includes this key document in some form or another. A will is used to designate how you want your assets to be distributed to your surviving loved ones upon your death. And if you die without a will, state law governs how your assets are distributed, which may or may not be in line with your wishes. But that said, not all assets can or should be included in your will. And for this reason, it's important for you to understand which assets you should put in a will and which assets you should include in other planning documents like a trust. So that's what we're going to talk about today. Now, my name is Sotera Anderson, and I help protect families and their legacies by helping them plan for the unexpected. While you should always consult with an experienced planning professional like us when creating your will, here are a few of the different types of assets that should not be included in your will. First, assets with a right of survivorship. So a will only covers assets solely owned in your name. So property held in a joint tenancy by the entirety, community property with the right of survivorship, they all bypass your will. And so those types of assets automatically pass to the surviving co-owner when you die. So leaving your share to someone else in your will is not gonna have any effect. So if you want someone other than the co-owner to receive your share of the asset when you die, then you need to change the title of the asset as part of your estate planning process. Second, assets held in a trust. Assets held by a trust automatically pass to the beneficiary upon your death or incapacity and cannot be passed through your will. So this includes assets held by both revocable living trusts and irrevocable trusts. In contrast, assets included in a will must first pass through the court process known as probate before they can be transferred to the intended beneficiaries. So to avoid the time and expense and potential conflict associated with probate, trusts are typically a more effective way to pass assets to your loved ones as compared to wills. But because it can be difficult to transfer all of your assets into a trust before your death, even if your plan includes a trust, you'll still need to create what's known as a pour-over will. With a pour-over will in place, all assets held that are not held by the trust upon your death are transferred or poured into your trust through the probate process. So if you meet with us for guidance on the most suitable planning tools and strategies for passing your assets to your loved ones in the event of your death or incapacity. Third is assets that have a designated beneficiary. So there are several different types of assets that allow you to name a beneficiary to inherit an asset upon your death. In those cases, when you die, the asset passes directly to the individual or organization or institution that you've designated as a beneficiary without the need for additional planning. And so I'll list for you some of the most common assets with beneficiary designations, and those assets should not be included in your will. Retirement accounts, IRAs, 401ks, pension, life insurance, or annuity proceeds payable on death bank accounts, transfer on death property such as bonds, stocks, wills, and real estate. 4, certain types of digital assets. Given the unique nature of digital assets, you'll need to make a special plan for those assets outside of your will. So a will may not be the best option for passing digital assets to your heirs, and in some cases, including Kindle ebooks or iTunes music files, may not even be legally possible to transfer by a will because you never actually owned the asset in the first place. You just owned a license to use it. So what's more is that some types of social media like Facebook or Instagram, they have special functions that allow you to grant certain individuals access or control of your account upon your death. So a will wouldn't be really of any use, but always check the terms of service for the company's specific guidelines for managing your account upon your death. Regardless of the type of digital asset involved, never include the account numbers, logins, or passwords in your will, because it becomes public record when you die and can easily be read by others. Instead, keep that information in a separate, secure location and provide a fiduciary with instructions on how to access it. 5, your pet and money for its care. Because animals are considered personal property under the law, you cannot name a pet as a beneficiary in your will. If you do, whatever money you leave, it would go to your residuary beneficiary, or the individual who gets everything that's not specifically left or identified, who would have no obligation to care for your pet. It's also not a good idea to use your will to leave your pet and money to care for your pet in the future to a future caregiver. That's because the name or the person that you name as a beneficiary would have no legal obligation to use the funds to care for your pet. And in fact, your pet's new owner could legally keep all of the money and drop your furry little friend off at the local shelter, which I don't think that's what you want. The best way to ensure that your pet gets the love and attention it deserves following your death or incapacity is by creating a pet trust. We can help you set that up and maintain, so that you can maintain a trust, and so your furry little family member can be properly cared for when you are gone. 6, money for the care of a person with special needs. There are a number of unique considerations that must be taken into account when planning for the care of an individual with special needs. And in fact, you can easily disqualify someone with special needs for much needed government benefits if you don't use the proper planning strategies. So a will is not a suitable way to pass on money for the care of a person with special needs. You should always work with an experienced planning lawyer to create a special needs trust who can make certain that upon your death, the individual who have the financial means that they need to live a full life without jeopardizing their access to government benefits. Don't take any chances. Although creating a will may seem fairly simple, it's always best to consult with an experienced planning professional to ensure that the documents are prepared properly, that they're created, executed, and maintained. And as we've seen here, there are also many scenarios in which a will won't be the right planning option, nor would a will keep your family or your assets out of court. So with this in mind, you should meet with us as your personal legacy lawyer to discuss your specific planning needs so that we can find the right combination of planning solutions for your family to ensure that your loved ones are protected and provided for no matter what. So I encourage you to please schedule a life and legacy planning session with us, and we can talk about all of those different strategies. I hope that everyone is doing well. We are again in the middle of another shutdown in California, and so please take care of yourself, and please take care of your families, and stay healthy and stay happy. Talk to you soon.